Cool. Okay, so Eitan, over to you. Do you want to just introduce yourself to everybody who's on the call and give us a little bit of your background?
Sure. Hi, everyone. Thanks for being here. I know some of you and others. Nice to meet you. Yeah, hi, I'm Eitan. I'm a technology and privacy lawyer. I work at a firm called Sheridan's. We've been going since the 50s. We're a technology and media practice. So a lot of what we do is in advertising, but we work for all kinds of technology businesses. And I run a privacy and technology team here. We've got about 140 lawyers, and I'm one of 19 of us who own the business and run the business. And I started advising affiliate companies pretty early on, actually, while I was still a trainee. And it just so happened I had a personal connection to someone who was starting out in that industry. It's moved on a lot since then. I would say it's become a lot more professional. It's become very well established. It was a little bit more experimental, I think, at that time. And it's touching on more and more things. Obviously, GDPR has a bearing on basically everyone and every industry, but a particular one for affiliate marketing and other kinds of marketing, and also advertising rules, given that this is about promoting companies.
Right, okay. So as I mentioned, if anybody wants to ask any questions, you can either email me directly, it's kevin.edwards@theapma.co.uk. You can ask in the chat, or you can raise your hand, and then when I spot you, I can come to you. So let's kick off today. So before I crack on with some of the questions that have been submitted, Eitan, I thought it would be useful for everybody if you could kind of paint a picture of where we are in 2024. So what are the kind of data and privacy trends generally, but then specifically how do they relate to our industry?
Okay, so well, there's a before time and an after time. There's a before GDPR and after GDPR. Before GDPR, basically everyone just did what they wanted. It was easy to do that because data was defined as being something which identified an individual. And so ad tech, in its wisdom, decided to just remove the person and just deal with identifiers, cookies, IDFAs, things like that. And therefore, GDPR or the privacy rules at that time weren't applicable. Then basically, I mean, my personal and informal view. Oh, before I get into this, I'm a lawyer, but this isn't legal advice. So if you need legal advice, you can either speak to us or speak to another lawyer. But there's formalities around how we're allowed to advise people, and this isn't the way to do it. So yeah, and basically what happened is everyone started getting freaked out by backpacks that were following them around the internet, and they recognized that we need to expand this definition of personal data, and that then included any data which would allow an individual to be singled out, and that all of a sudden puts all online advertising in scope. That kicked in in May 2018. GDPR harmonizes the rules across all of Europe, which is a good thing. The UK is, since Brexit is no longer in Europe, well, it's no longer in the EU, but the rules are very much the same. GDPR does allow for some sort of local configurability by nation states. So member states and also the UK are able to make they can tinker around the edges a little, but not in a meaningful way, just enough to allow them to reflect their own kind of customs. Since Brexit, we basically created this thing called UK GDPR, which is a cut and paste of GDPR. And we do have, as a country outside of Europe, have the ability to make changes to that. But in reality, we don't want to, because we have been whitelisted by the EU as a safe place for the EU to send data. And if we make too many changes, and we reduce the protections for individuals, or deregulate privacy too much, then basically the Europeans could say it's no longer a safe place. This happens with the Americans constantly, and then they implement something to try to allow it to be whitelisted, and then it gets challenged. So they're kind of in and out all the time of the good list of countries. And so basically, yeah, we could change our rules completely, but we're not going to, because we don't want to jeopardize the open data flow that comes between the EU and the UK. And that's kind of where we are now. Oh no, the last thing on that. GDPR is massive and it applies to so many different things. Around 2018, I heard a commentator say, it will take us 10 years to work out what GDPR really means. And that's because you have the law, but then you have the guidance, and then you have enforcement, and then you have court cases and appeals and things. And all of this is putting more specificity and better defining what these rules actually are. And then you can look at the rules and say, this is how it affects whatever technology or business practice. And so we're kind of in that process now. I think 10 years is probably fair. And yeah, so I'll come back to that, but I'll leave it there for now.
So we're halfway through. So just on your point around tinkering around the edges, so the new Data Protection and Digital Information Bill, which is not yet law, if I'm correct, it's currently in the House of Lords, I think. Yep. Would you consider, I mean, what are the details of that are relevant to this audience, but would you consider that to be kind of tinkering around the edges?
Yeah, and explicitly so, because DCIT, which is the government department that spun out of DCMS and kind of created, or is basically pushing this along, have said privately, and I also think publicly, we aren't going to do anything to jeopardize adequacy. So, yeah, in some cases, they're sort of changing things like there's an obligation to keep a record of what data processing you do. And they're going to say you don't necessarily have to do that, but in practical terms, you do have to do that, because if you don't know what you're doing and have a record of it somewhere, how do you comply with everything else? Similarly, they're going to change from a data protection officer to a different type of appointment, but there'll still be someone who's going to have to be in charge of privacy. And what's probably most relevant to this group is changing the way, reducing the number of cookie pop-ups we're all dealing with. That's the kind of thing like a Tory government can, or any government can kind of get their heads around. Like, there's just too many pop-ups. Let's do something about it. And so part of it is to an extent deregulate cookies, but it wouldn't be in a way which is ripping up the kind of GDPR rulebook, so to speak.
Okay, so I mean, that obviously leads me very neatly into the main part of the main topic of conversation and the main bulk of questions that came through, which is around cookie classification and cookie categorization, which is inherently linked to that topic of pop-ups and CMPs. So I guess for the maybe less initiated, let's go back to basics. And first off, can you explain what we mean by cookie classification, and then go on to talk about the different types of cookies that there are?
Okay, so you have the thing about cookies is they sit in two sets of rules. They sit in GDPR because they relate to an individual. They allow an individual to be singled out. Therefore, they're in this new definition of personal data. There's also a separate set of rules called the Privacy and Electronic Communications Regulations, PECR, but people call it PECR. The PECR rules they're more akin to the old privacy rules. So it's nation states doing their own rules, but they're required to do it along a certain set of lines. So when Europe legislates, either they say, here's a regulation, we're all going to share one law, or they say, we direct you to make a law along these lines, and then everyone does it. And then you get much more fragmentation. The old privacy rules are like that. In Europe, we're still dealing with the privacy and communications rules, known as e-privacy. They're still fragmented. There is still supposed to be a companion law to deal with privacy and communications, which is to do with cookies. It's basically a rule which says you have a human right to people not to read your post. And then you extrapolate that, and then it turns into you have a right to people not read things on your device. And that's kind of what a cookie is. Whereas GDPR is you have a human right to a personal life, which is very similar, but it's not quite the same. And so when you look at a cookie as personal data, it can do all kinds of things, and you can categorize it as doing different things. When you look at a cookie from the perspective of e-privacy, it really doesn't matter. It actually captures cookies which aren't even personal data. So that could be a cookie which records the language preference or something. That's still a cookie. But it breaks it into two kinds. You've got cookies which are cookies, and then cookies which are considered to be strictly necessary. And that is necessary in order to deliver a service that the individual has actually asked for. It doesn't have to be a paid service, but it does have to be something they actually want. And those are effectively the two types of classification. This is clouded because consent management platforms and also things like the TCF try to break it down. And they're really breaking down the cookie as personal data. And they're bunching it up into these different groupings. So you'll have like performance measurement, that kind of thing. That's not actually from a legal grounding. That's more from a practical thing because they're trying to offer a platform to lots of companies, and it needs to be a one-size-fits-all kind of solution. So it doesn't fit anyone perfectly, but it fits most companies pretty well.
So the measurement, advertising, marketing, however you want to classify it, that's come from industry. That's not that there's no legal definition around that.
Yeah, basically, yeah.
And sometimes we refer to them as strictly necessary, essential. Is one legally the right term, or are they basically the same thing but they're
strictly necessary is the right term, and that's a term I tend to use. But essential, I mean, let's face it, it means the same thing. And but really, it's essential for what?
Yeah.
So it needs to be strictly necessary for the service that people want. The most hackneyed example of that is to remember the goods in your basket when you are at a checkout. You can also say that and that could be any functionality that the person actually wants. You're also allowed to call security cookies strictly necessary, and also cookies for load balancing and stuff, so that the website doesn't crash. But that's more of an edge case. And basically what we're talking about is cookies for the service, and then cookies for everything else, which is usually to generate revenue for the business. But the fact that the revenue is what's allowing the service to be given, especially in affiliate marketing where services are usually free, that's not considered to be strictly necessary. So you can't say that we have a cookie to generate ad money, and that allows us to provide the service, and therefore it's strictly necessary. That doesn't wash.
Okay. And if anybody's got any questions, or if anything's not clear, then please do chip in. And in terms of how we therefore think of affiliate cookies, obviously we would typically think of them as being not strictly necessary, but that again is slightly clouded. I know it's open to interpretation, but can you kind of talk around your take on where affiliate cookies sit?
Okay, so affiliate cookies are, for some frankly unknown reason to me, considered to be an advertising cookie, presumably because marketing appears in the phrase affiliate marketing. My view is that they can't necessarily, they can't be an advertising cookie because they don't fire until after the ad is served. And they're not used on the next ad because they're not supposed to be using affiliate cookies to, let's say, measure a bunch of different measure a bunch of confirmation pages, and then group it together and build a profile of the things that person has bought. So what it's really doing is measuring the performance of the ad by connecting the action, the A part of CPA, with the referral from the publisher. Affiliates, their job is basically to get traffic to their website so they can pass it along to advertisers. And obviously, there's lots of different ways to do that, but there are some very prominent ways, loyalty cashback incentive being one. And that is under our advice, that is a service that the individual wants. They're coming not for the thing they go on to buy. They're coming for a service which enables them to receive rewards or cashback or incentives. Another one is voucher codes, which tend not to actually need a cookie for the voucher itself. You need it to understand the performance, but in some cases you do. And if, let's say, you need it to make sure that a unique voucher is being used properly, then you would argue, we have argued, that it's effectively a security measure, because someone's coming for a voucher service and you can't offer that service, and if it's going to get spammed all over the internet, and that's why unique codes exist. So it's effectively like a security measure within the code. That's, I think they're both fair arguments. The voucher one's probably not as robust, not quite as robust. But if, let's say, you'd have text links on your website and you're just monetizing text links because you've got good content, then that's unlikely to be considered to be strictly necessary, because people can read the text. They've come for the content, they can read it, and the cookie didn't help them. So it's not necessary to do that. You know, the service they want is the content, not the thing that's being linked from the content.
And there is so going back to the point around adequacy and, you know, the harmonization of rules across Europe, the French data regulator in 2022, I think it was, very explicitly stated, they made explicit reference to cashback, voucher, reward based cookies, and they said that they could be considered strictly necessary. How much can we lean or rely on that kind of statement and apply it in the UK?
Well, it's not come up. I'll do it in stages. It hasn't come from our own regulator. So it's lovely when a regulator says something and it's really clear and you can just go and do that and know you're in the clear. You know you're complying with what they say. When a regulator gives guidance, it doesn't mean not following the guidance is an infringement. It does mean following the guidance won't be. So as long as you stick to the guidance, you're blessed by the regulator. If you don't, then you're kind of on your own, and you'll have to demonstrate it yourself. But what's good is it's, you can't really prove a negative, but I'm pretty confident the regulators never said we disagree with CNIL, and which is the French equivalent, and cashback is definitely not strictly necessary. And when you piece it together, it shouldn't really be that controversial. I don't think the CNIL statement really generated any kind of particular, didn't really flare up because of that. And the logic seems pretty straightforward. And cashback services work hard to deal with customers who are disappointed when they don't get their cashback because the cookie didn't work. So you're finding yourself with a customer who wants a service, and absent the cookie, they can't get it. And now you therefore argue that cookie was necessary.
Okay. Just to dial back to the start of this conversation, we talked specifically around cookies, but because this came through in a couple of the questions. Specifically, when we talk about, I believe is the terminology cookies and similar technologies. So can you just talk around what that specifically means from an affiliate tracking point of view, I guess?
Okay, so at its heart of it, a cookie, or the technology within scope, I'll say that, is anything which stores or accesses information on the end user's, what they call terminal device, so the end of the internet. So in this case, I'm on a laptop. That's my terminal. That's my terminal. That's my device. If you can store or access information on here, which is like a cookie in the browser, or anything similar on a mobile device, then that is going to be a cookie. If you are tracking people in your own servers, then you're not using cookies. But often you end up needing a cookie anyway in order to find them in your server. So you know which devices are which. But it's effectively any device, any technology which is stored or accessed on the device. So it gets pixels, tracking pixels which load often in like email marketing. That would be quite prevalent. Fingerprinting has also been lumped into this. So device fingerprinting, where you effectively take lots of different data points, and it's a probabilistic, so it's not a guarantee, unlike a deterministic identifier that you've put there for that purpose. But you use it to create some kind of user agent, which will then allow you to say this is this person, and then you can treat them differently, and then you're in the scope of GDPR because it's personal data. More recently, and I have some difficulties with this, the European European regulators formed a kind of European regulator supergroup called the EDPB, and they have representatives from each regulator for privacy from each member state. The UK is no longer in it. They came out with something which was to say that if you put any content even in a cache, or anything in a cache in order to run it, that counts as storing or accessing. But the implication of that is effectively the whole internet is just one massive cookie, because websites need to cache things, because otherwise it's too slow. You couldn't even argue it's strictly necessary, because eventually the information is going to pass. So they got a huge amount of pushback on that, and I think quite understandably. And I wonder if they'll back down, because I just don't know how on earth they're able to. It feels like a very technical point, and these cookie rules have been around since 2011, and no one's ever mentioned or had a problem with caching. So it feels like horrible regulator overreach from the EDPB. That's my personal view, and that, frankly, is also my professional view. And yeah, but cookies are storing or accessing information on individuals' devices and browsers and stuff.
Cool. Okay. So if anybody's, as I say, if anyone's got any questions, feel free to stick your hand up, or if any kind of lack clarity on that. One of the to go back to stay on the consent topic. Someone asked a question around where you can collect consent. So if you're a publisher, for example, and you have a CMP and somebody allows the cookies, is that a point at which you can collect consent for the for that journey that potentially then leads on to an advertiser site, and then that person makes a transaction?
So there's a massive practical implications to this, and it's a very difficult problem to solve technically. But from a legal standpoint, you don't necessarily have to collect it yourself. You can outsource that to someone else. Legally, you then need to make sure they're doing it well. You need to be able to check up on them and deal with other things that relate to consent. So if a person decides to withdraw their consent, how do you then manage that? But the legal concepts behind it are you don't necessarily have to do it yourself. You can also work with other people to obtain consent. That's perfectly legally acceptable to do that, and that's what the TCF is seeking to do for like 1,500 vendors all in one hit, which is a separate issue. We can discuss that in a bit, but the idea there is that publishers are being made to obtain consent for intermediary vendors who don't have an interface with the consumer and therefore have no opportunity to get it for themselves.
Okay, I'm going to read this question out word for word, just so I get it right, because it's quite a long question. So clients are often overly cautious around what tracking codes are used when consent is not granted. Most would prefer to disable marketing tracking completely to avoid fines. Since GDPR, from a data perspective, is there any assurance we can give to the clients that it's safe to fire our tracking regardless of user consent, as long as we only track on the data the user permits us to use? While tracking can and does use first-party cookie tracking to get the most accurate data, the tracking script can use more anonymized data to comply with GDPR, and we need clients to understand this. I hope that makes sense.
It makes sense. So just to kind of set the scene a little, and you may have got this impression from some of my other answers, the regulator is viewing this from the perspective of the individual. So really, it's a question of understanding what does the individual expect when they finish your engagement with them. If and also what I've mentioned earlier is that there's the cookie itself, which may or may not be personal data, and then there's a cookie as a form of personal data, which obviously would be relevant to a single individual. So if a person has rejected cookies and they've said, you've asked them, do you want cookies? They say no. And they're now not expecting you to do something very similar, but not quite the same. Their expectation is that there is not going to be something stored or accessed on their device, unless they're asked again and they change their mind, or it's essential and therefore out of scope. because interestingly, you don't even need to tell them about the strictly necessary cookies. They appear in CMPs as a sort of not untickable opt-in, but actually it's good practice, but you don't actually have to do that. So I'm not sure of the exact context for this, but if a person refuses consent to a cookie, you have to really interpret that as a refusal of consent to anything similar. If you want to track them on your server, so server to server tracking, that would be okay, because you can probably, and we have advised for some of our clients that this is acceptable, you can probably process the personal data without the consent. And if it's on the server side, you're not using a cookie, and therefore you're not storing or accessing, and therefore you don't need a cookie consent. But practically, your server is going to have loads and loads of information in it, and you don't know which browser's which. So how do you then marry up the individuals in one bucket of server information with that of another? And I'm saying here between the publisher and the advertiser. That was more of a garbled message, but I can clarify if it didn't make good sense.
I mean, I've got one more question that I want to ask specifically on cookie consent before we go on, because I appreciate we've talked about this in the entirety of the course so far. Obviously, we could have a whole session on this. If anybody has got any additional questions beyond the one I'm going to ask, then please do stick it in, and we'll leave 5 minutes at the end if anybody's got any additional comments to make. But I guess just hopefully I've done justice to the questions that have been asked. There were, as I say, we got a lot of questions around cookie consent. The last question I really wanted to ask is really kind of like a practical approach, because I spotted on LinkedIn today, one of the APMA members posted that a brand had, I think it was to do with cookie consent, had done something to cookie consent without any consultation. Seen it, obviously the publisher had seen a drop in conversions. There've been no conversations around this was going to happen. There have been no conversations around compensation. Now, there's obviously commercial things that the industry can do to try and mitigate some of the impact of this. But there's lots of people on this call from networks and agency side, and they will be wanting to have a fair and balanced conversations with brands and proactive conversation around this. Kind of what would be your practical advice about how to go about talking about this in a way that has limited impact or limited effect on affiliate programs?
Yeah, there's a huge kind of context to this, both historical and also prospectively. Historically, the UK regulators have done nothing about cookies, and basically has only really recently decided to get involved. There's almost no enforcement action in the UK regarding cookies. People, including the regulator themselves, were doing basically cookie as an opt-out. The ICO had a cookie consent thing on its website, which cookie consent, to be good, has got to be freely given, specific, informed, prior, revocable. And each of those things is quite hard to do. But the ICO's own cookies were done in advance. They were bundled, and they were using a tool which they configured to ask for consent after the fact. And no one cared. There were also like pixel tracking on their newsletters and stuff like this. More recently, there's been a change in stance. Since GDPR, people are getting consent, but are they doing it well? And that's really what this whole thing is about, with the size of the reject all and where it is, dark patterns, behavioral science, all that. The new information commissioner does take cookies more seriously. He's had run-ins with Facebook in a previous life, and he is saying at presentations and stuff, come on guys, enough's enough. You know what consent looks like. You're dragging your feet, just get on with it. I don't know why we keep having this conversation. But where that's left us is with business models which kind of depended to some extent on the higher conversion rates for cookie opt-ins. That's the history. Prospectively, there's this new rule, there's this new DPDI rule bill. So this is what's going to vary. It's going to vary UK GDPR, but not too much to piss off the Europeans. And one of the things it's going to do is, or which is under discussion, is to remove the consent obligation for measurement cookies on website analytics. And a lot of the noise is about, well, why stop there? What about measuring the performance of an ad? And that's basically what attribution's doing. So if those amendments go through, then there's a strong argument that an attribution cookie is a measurement cookie for an ad and then comes outside of the consent obligation. Now, when a law gets passed and it starts off as a bill, it's changing because it's being negotiated, right? Later on, it becomes finalized, but then there's an implementation period where it's not actually the law. During that window, regulators don't really want to go there, because if it used to be the law, if it still is the law, but everyone knows it's not going to be, then why make a stink? And generally, the regulators' focus when it comes to cookies is about the profiling. Profiling has got, from a policy perspective, has got some very serious implications. It's being, some of these cookies for profiling are being used for voter suppression or for other things like that, which actually have an impact on society and democracy. The plucky little affiliate marketing cookie is not one of those. So I would try to take that perspective, but ultimately you do have to respect that advertisers have their own policies. And in the past we've said, look, just treat this cookie like you do all your other cookies, because we know they're all being waved through. They're not really getting it for proper consent. There's a thing that says we use cookies, great, and it just comes and goes, and the cookies are all served before the page even loads, and no one's got a problem with it. Now we're seeing more focus on cookies because mostly because of the impact of profiling cookies. But I would like to see that affiliate marketing cookies be treated as measurement, attribution, and so in those conversations, I think it's important to put it into that kind of context. The other thing is that affiliate marketing models tend to be more services based. So cashback and loyalty, vouchers, things like that, price comparison to an extent. A lot of those cookies, I think, are strictly necessary, and therefore they shouldn't be treated they shouldn't be treated like this. They need to be. They shouldn't be treated as a performance marketing cookie. They need to go outside of the entire consent paradigm. Instead of being yes or no, the question shouldn't be asked. And that really comes down to how advertisers implement their CMPs. What you'll no doubt, which you all know better than I do, advertiser DPOs tend to hear the word marketing and say this needs consent.
Is there, I'm putting you on the spot now, because I haven't looked recently, so I couldn't give you any, but are there any good examples of CMPs that you think are kind of fair and balanced from on a kind of like an advertiser or any kind of website that's out there?
I don't think there's any that like genuinely suit. I honestly, I think that I think a strictly necessary affiliate cookie should not be in the consent thing. And then no one's saying we use a cookie so when you load the next page, we don't forget what you just put in your basket. No one's mentioning that. I think a lot of affiliate cookies need to be in with those ones. When TCF v1 came out, it was very, very cheers, Julia. When TCF v1 came out, it was basically by ad tech for ad tech, and then publishers were sort of like, well, hang on a minute, we're the ones getting the eyeballs in the first place, and you're making us do all these things, and we don't agree. And it became much more publisher friendly, and also allowed it to be used actually to benefit publishers, even if it didn't benefit the rest of ad tech. And a big thing was this legitimate interest categorization, which was the ability to say, we're processing the personal data on a non-consent basis. Because when it comes to e-privacy, you've basically got consent and no consent. When it comes to personal data, there's 6 different options. And one of them is a people refer to it as an opt-out, and if you really reduce it down, that's correct. But it's the idea that the processing is being done for a reason and for a good reason, and the impact is low, and therefore there's a proportionality to it. So the cost to the individual's private life is so low, and the interest of the company is reasonable enough that you're not going to bother with consent for this. And I could go on about that because it's really the most flexible sort of way to justify what you're doing lawful.
Got a question here coming from Anne. Does the IAB's consent framework harm affiliate marketing by association because it defaults many affiliate network and partner cookies into classifications other than strictly necessary? I think you kind of covered that earlier by saying effectively yes, didn't you?
It doesn't help. I mean, affiliate as a share of the ad spend it's not the £900 gorilla. Can't get out of it.
Yeah.
I think often it's a kind of practical situation there. You know, we see networks and publishers implementing TCF because it's been agreed somewhere that this is what we're all going to use. And you don't always need to do it, but you kind of do commercially because otherwise it's basically a prerequisite for working with some companies. But it doesn't help. I don't think attribution is advertising. It's measuring the performance of an ad, and that there's a nuance there. And when you tell people it's fired after the advert, they're like, well, it can't be. You know, it kind of makes it clearer. It's for something else.
I mean, just finally on this, because we've got some other topics that we want to cover off in the last 15 minutes, but the ICO have published on their website a letter to the IAB and the AOP. This is like acronym overload this session. The Association of Online Publishers, that is, they had a meeting with them, which I wasn't aware of. I'm not sure if anybody who are members attended. And they have published the response to that, and that indicates to me that the AOP are having a similar conversation around measurement and measurement cookies for a lot of their activity. That was the inference from the response from the ICO. So there's a chance that our channel broadly is on their radar. They refer to ad affiliation, and we've included, and that's one of the reasons why we submitted a response to the ICO's recent call for views on consent or pay. But is it, Aitam, is there anything, if anybody else has got any other additional comments or wants clarity, or, and then again, as I say, please do post them in the chat. Okay, there's a few other non-consent. Let's move on from that topic, as we've been talking about for quite a while. So I had a couple of questions around, I suppose, advertising law and regulation specifically. So there were a couple of questions around the ASA in particular. So I'll read out the question. That is, where does the legal liability lie if an affiliate partner does something wrong, i.e. misleads customers with false advertising, when several parties are involved, i.e. the publisher, the brand, the platform, agency? You know, there could be multiple people involved.
Right. So first of all, false advertising isn't really a thing. Advertising needs to be non-deceptive. It needs to be lawful, decent. People always say, "Oh, it's false advertising because it didn't include the thingy." But there's a whole code on what is a proper ad. And sorry, no, that's not true. There's a whole code on what is a compliant ad, and the liability primarily sits with the advertiser, but there's a kind of a secondary responsibility for publishers, networks, and others who kind of make it happen. So if the answer is basically everyone, but mostly it's the advertiser.
Okay, I think that answers that. I think when you look at the ASA, if they ever publish any rulings, it makes it quite clear that the advertiser has to take responsibility, even though they would. I've seen many advertisers plead ignorance because they kind of run their affiliate programs without kind of due due care and diligence. Another question I had, which was concerning advertiser contracts and network contracts around if a program moves from one network to another. Very often there'll be restrictions in place around the new program not being able to approach affiliates for a certain amount of time, which obviously is quite restrictive because it's natural for a program to want to migrate those affiliates over. Where legally do publishers stand and to networks and advertisers stand about continuing to work with those publishers?
So it is possible for two companies to agree what's known as a restrictive covenant, which is an obligation not to do something. You see it also in like an employment context. You can't leave the business and set up in competition over the road. In employment context, there's a much sort of firmer fairness principle, and basically, if it's unfair, then it is not enforceable. When it's company to company, the fairness requirement is lower, and generally it's acceptable to take on an obligation. If a company has signed a contract which says I won't do this, then they can be held to it. But from a competition point of view, it changes things, because if you are very big by market share, and that's known as having a dominant position, then you're not allowed to abuse it. So it's not lawful under competition law to abuse a dominant position. And so if you're massive, one way to abuse a dominant position is to sort of flex and try to tell people, if you're working with me, you can't work with anyone else, or if you break up with me, you can't do this or that. And it's very much depends on the companies, but restrictive covenants are effectively lawful, and but they are subject to sort of enforceability parameters, I'm going to say, and then practically speaking, how you police this, how you enforce this, is very difficult.
Okay. Right. Let's move on to something else. AI. Just throw that in. Obviously, it's a huge topic, not just for our industry, for everybody. Where are we in terms of there being, where are we in terms of a statutory regulatory framework around monitoring AI, and also how is it impacted by rules around personal data?
Okay, so the short answer to the first question is nowhere, and we're not going to be, because the plan is to regulate it through existing regulation, and to not, in the UK, to not have an AI Act, so to speak. But in the EU, they are putting that. I don't know if that will stay the way to go. And especially Gen AI is moving so fast that by the time they come up with these rules, they'll probably need to start to think about changing them already. From a privacy point of view, well, the problem with AI is the machine is teaching itself, and you don't necessarily know how it's doing that, and you also don't necessarily know how the outputs have been arrived at. Now, when it comes to personal data, people have a right to know what companies have on them, and also how they came to the conclusions they did, and they have a right not to be subject to an automated decision without human oversight, in some cases, in most cases. And AI doesn't make it impossible, but it does make it difficult. So there's a lot of kind of guidance out there on like how you describe what goes on inside the black box, and you can sort of explain in general. You don't need to give away your secret sauce if you're using AI when you're explaining transparently what you're doing with people's personal data. But it does make it more difficult, because sometimes people don't know them. The operator of the AI doesn't know themselves, because the whole point is it's machine learning, and they weren't taught by a human who then knows everything the machine knows. Can I get you there?
I mean, it's I mean, it's such a huge topic. All right, I'll Somebody's saying thank you. Okay, so I wanted to, we're coming, we've got about another 5 minutes or so. So if anybody's got any additional questions, please fire them through now. Or if you've got any other questions that you want as a follow-up, then please just drop me an email. So I know that you're a UK lawyer, but a lot of the companies represented on this call will be multinational, have kind of multi-territory businesses. With your kind of overall kind of umbrella view of what's happening elsewhere, where are we in terms of North American regulation around privacy? Obviously, we have the California Privacy Rights Act, which is quite different to GDPR, but I believe there's some changes coming down the line on that. So where are we in terms of North America and maybe other territories in terms of kind of data privacy laws that they're thinking of bringing in or changing?
Okay, so yeah, the US is quite far behind Europe when it comes to privacy. Someone once said to me, the Americans don't understand privacy in Europe the way the Europeans don't understand owning guns in America. And it's just not really something that we as Europeans are into. And perhaps the opposite could be said in reverse. You know what I mean? Perhaps that's actually true. There are state by state different rules popping up. They aren't usually aren't quite as heavy as GDPR. The California laws are they're the ones that draw everyone's attention, probably because of the size of the market, probably because they're more prescriptive. They have rules in there which say things like you have to have a link which says do not track. So it's a bit like a DMCA notice, for taking down infringing IP, where there's an actual framework you have to follow. What's interesting about the approach they've taken is that the European and UK versions of privacy, they look at why we're doing this data, and then they try to they make the company justify that it be okay, that it is okay, and implement things to make it okay. In the US, it's really more about where the data is being transacted and how it's being transferred. So it's more about the data flow rather than fundamentally the purpose at heart. I think federal law is on the table somewhere, but I'm not sure where. But inevitably there will be a federal data law, and that's likely to kind of overwrite a lot of this. But we work with US lawyers, and they mostly are able to advise on the different states, but that's going to get harder and harder to do because the fragmentation in America can be insane. And it's just not something we're used to. I suppose in Germany, you do have a federal system too. They have 16 ICOs over there, and then they try to coordinate. But obviously, these are all international businesses. So the fact that you are, compliant in Illinois, like, great, you've got Chicago, but what else is that getting you? So, you've got the whole rest of the country to deal with, and practically, I suppose everyone just goes for the highest standard. But mostly what people would, when we tend to work for EU, UK businesses who go over there, and then the US lawyers will help to add things to make it US compliant in terms of the notices that have to be provided. And when we receive work from our US counterparts, we usually start again. We tend not to just take what they've got and augment it for Europe. We often say, you know what, we might as well just, we obviously have documents and things that we like and we know and we trust, and we don't price for the template. We price for the work made to do on the template. So they tend to go for that. But it's clunky because they're not quite the same, and they also seem to have different sort of underpinning to them.
Okay.
I'm not sure that answered your question.
What
was the question?
Just generally in terms of kind of any new legislation or new rules coming down the road that people might be interested in or might be relevant for their businesses. I suppose, Europe's a bit easier because it's as you say, should be one standard, but more specifically around North America. But as you say, there are kind of these variety of different individual privacy laws, the California one gets all the attention.
Yeah, it does. But federal privacy law is on the way.
Okay.
In the medium term.
Just kind of on that kind of more global view. I mean, the UK, both in absolute and by per capita terms, is the dominant digital force in Europe, but we're not in the EU. How much has Brexit impacted our kind of ability? Obviously, we're not in the room, we're not having conversations around legislation, but around things like decisions that the ICO makes. How much weight do they and importance does the EU place on those?
It doesn't disregard them, as I understand it, but we are no longer part of the EDPB privacy regulator supergroup. So we don't have a voice in those conversations. Sometimes you'll see the EDPB will cross-refer to something that ICO has said, but the ICO doesn't have a right to be in the room anymore. And so when that guidance comes out, we have less say. But we also, the quid pro quo, you would argue, is that, but it means we're able to deregulate in some ways, or regulate differently in other ways. But because of our dependence on this adequacy decision, which is an approval from the European Commission that the UK provides an adequate degree of protection for EU residents when data comes to the UK, there's a lot of leverage there. So in real terms, we definitely, I mean, just one multinational operating across Europe, it's like a major pain in the ass if you can't let the data flow between your subsidiaries. And so we can't do whatever we want with data in the UK. And what's also interesting is that a big part of the stink between the EU and the US over the years has been down to the PRISM scandal, which was the disclosures by Edward Snowden. And this is about big tech companies backdooring their information to the NSA and the FBI. The UK, the GCHQ was also rolled up in that. But because we were in Europe, we got a pass. Potentially that will become relevant again, but I don't know where that is. I'm just sort of putting it out there as a hypothetical.
Okay, we're just about to wrap up, but I just wanted to kind of loop back. Well, I referenced it earlier, the consent or pay call for views that the ICO has just put out. My assumption is it's linked to Meta's decision or announcement that they were, if people didn't, for those of you that aren't familiar, for consumers have a choice. They either accept advertising or Meta may kind of effectively paywall it and charge for it. And so the ICO has put out this submission asking for views on, I presume, kind of what the impact is. That they put a questionnaire out about it. We submitted something for it. What's your reading of what could happen, and also how it could impact the affiliate industry?
So this is an interesting one, because the backstory is that Facebook's basically been trying everything to get out from having to do consent for its behavioral marketing on its platform. Consent can be valid. You can say to someone, either consent to this or pay, or rather, to put it another way, you can charge, you can buy people's data in that sense. You can reward them for letting you do things with their data. What you can't do is punish them for not. So there can't be a detriment. The UK's position is that consent or pay can be lawful. This is to do with a European case, which actually happened a little while back. They're consulting on this at the moment. A lot of people fed in, and there's a caveat, and the caveat is that if it's consent or pay, but if you don't want to pay and you don't want to consent, you then suffer detriment. Like, for example, if this was done by, Brighton and Hove Council and you can't get a parking permit, then that's not allowed. So that would not be valid. And they basically provide for that in the context of like public services. What's wackier is that it's actually not wacky. I mean, it's kind of got some legs. the EDPB are saying, well, actually, very large online platforms like Meta, they're so important to our society that it would not be valid consent for them to ask. So, for example, LinkedIn. If you don't want to pay for LinkedIn, if you can't pay for LinkedIn and you don't want to consent, and you want to get a new job, and you closed out of LinkedIn, does that affect your life? Because if that has a detrimental effect on your life, then the consent or pay would not be valid for LinkedIn. And so there's this discussion now about, well, if you can't get on Insta, is it affecting your right to live your own social life? To what extent does Meta have, we have utilities in this country, right? The rail network, water, power. They're subject to specific rules relating to them because they're so important. Everyone's got to get around on a train. Everyone's got to drink water. The question is whether now these companies are so big that they've become utilities in themselves. And we've already reached a tipping point because there are already laws in the UK and in Europe which kind of are bespoke to individual companies because they're more powerful than most of the member states in the EU bloc. So that is a kind of wait and see kind of thing. I think for affiliates, it's not as handy as we'd like it to be because I don't see an advertiser doing consent or pay. I can see a publisher doing it, but that's not where we want the cookie. Obviously there are cookies there, but the conversion is really what we want to measure. Mm-hmm. So it's less of a benefit, but it does help drive to the surface the whole value exchange conversation, which has been, I think ad tech kind of took the piss a bit. They pretended they were doing this out of the goodness of their heart. Now it's become more obvious that actually the cookie is good to have the cookie for the business, and it's good to have the service for the individual, and let's do a trade. And we can then haggle over what the value exchange is and make that a fair exchange. I think it will drive that conversation up more, and I think that it's difficult to know in my kind of techie bubble that I live in, but I think people are able to understand that actually, yeah, you can get this Hotmail account for free for 25 years, never paid a penny. Why do they do that? I think we can start to have those conversations.
Mm-hmm. Yeah, I think, and we've seen various different surveys. There was a really interesting one The Economist did recently, or a couple of years ago, trying to contextualize the value to consumers of those free services and how much people would be willing to pay, would have to be paid in order not to have access to them, and all of that kind of quite conceptual stuff around, how, as you say, utilities and services and how people view them. It kind of goes to the heart of this topic. Yeah. Right, we're out of time. We've kept everybody for an hour, so there's no more questions. So thank you all very much for joining. I will follow up with an email with a link to this this recording, and also a feedback form as well. So if you could fill out the feedback form, then that will help inform future Q&As that we do. So I just want to say a big thank you to Eitan, and thank you all for joining. Thank you very much.
Thanks, everybody.